people can see it online if they go to our YouTube channel.
Well, hopefully it doesn't strobe on that camera.
Yeah, oh, it might. It's very colorful. Very nice. It even matches your outfit,
Well,
I think.
I think this one was approved, but my daughter was sleeping when I left, so
Oh,
I'm not
okay.
sure I had the chance to get it reviewed by the committee.
Well, there you go. In any event, we appreciate your stopping, and we're going to talk a bit about, I think this U.S. Supreme Court ruling on the breathalyzer law in Minnesota is very interesting. We'll touch on that, and then we'll talk about coordinating between your office and the law enforcement agencies throughout the county, because I think that might be an interesting topic too.
Yeah.
You need it repaired right away. You need to call Metal Services of Blooming Prairie. Metal Services has worked hard to earn a reputation for superior work in metal fabrication and repair. Metal Services team of certified, experienced fabricators will have you back up and running in no time at all. When you can't bring it in, they can come to your field with their portable welding service. So when breakdowns happen on the farm or in the field, call Metal Services in for prompt repair service. The number to call 583-2144. Metal Services of Blooming Prairie, serving the farming community for over 30 years.
Once again, good morning, everyone, and welcome to today's edition of AM Minnesota. John Fossum, Rice County Attorney, is in studio here today. I'm going to shut down my ringer, silence it so you don't hear that on the air, but you can text us any questions you might have, 838-5233, area code 507, 838-5233, if you have any questions for our Rice County Attorney. We appreciate John taking time from his busy schedule to be with us. I'm assuming you're very busy these days.
Yes, we are very busy these days. We have a lot of things going on. We got our drug task force has been picking up a lot of people on drug arrests. We have, of course, all of our regular work. We have a booming caseload of child protection cases that keeps our office busy. So yeah, we've got a lot going on all the time.
How is drug court going?
We had our first successful graduate of drug court a couple of weeks ago, and that was tremendous. And there was a nice story about it in the Faribault Daily News, and a young woman who really turned her life around. She started in drug court before I got there, and she managed to get through the whole process without a lot of the issues that some of our other participants have had. She was just very focused on, having this time with her family and her daughter and working and doing well, and she is. And I think she should be tremendously proud of what she's done, and I'm tremendously proud of what she's done to turn her life around. Just imagine, the years that would have been wasted by sending her to prison.
And that's what the drug court is for, right?
Right. We want to keep people as taxpayers and not send them to prison if we can avoid it.
Yeah, well, a drinking problem and being a criminal may be two different things.
Well, that's right, and it wasn't so much a drinking problem. I think there were other drugs that she was using, and a lot of the people we have heroin, people with heroin issues and meth issues and drinking problems, but yeah, being addicted, having substance abuse issues is not the same as being a violent criminal.
And that's what they're talking about too, the Sentencing Guidelines Commission, I know, talking about looking at it differently.
That's right, and the Guidelines Commission has issued a recommendation which the legislature can either reject or change if they want to do that. If they don't act on it this year, then those recommendations from the Guidelines Commission become the new guidelines, and there will be a lot fewer people heading to prison as a result of drug offenses as a result of all that.
Now, I know that you don't make the laws, obviously. Your job is to enforce whatever laws are on the books.
Right.
But you must have some sort of an opinion on this. You think this is the right way to go, or?
Well, the County Attorneys Association had a different proposal, and I support the County Attorneys Association proposal. What it does is goes back to the statutes we have and changes the statutes so that it requires a larger amount to reach those higher penalties. And my concern really is the people that we find, and even if it's the first time that we run into them, if they have a large amount of drugs, somebody with a suitcase full of cocaine or meth or whatever, the idea that they get the same sort of treatment as some other first-time offender who just sells 10 or 12 grams of cocaine is, you know, and someone who's got, you know, half a pound of cocaine seems to me should be looking at a harsher sentence, and that's my concern, is that when we run into our first-time drug dealers, that we're not giving them the kind of break we're looking at the people who are simply selling to finance their habit.
So under the proposal that's currently being made, that differentiation isn't made?
That differentiation is not as easy to make, and so it lowers the prison sentences available for everyone. And it does make some changes in terms of the ability to seek an upward departure for someone who's doing a lot, who has a lot of drugs in their possession or who's sold a lot, but it doesn't, you know, to me it minimizes serious conduct more than it protects the people who are really kind of the small-time users. And what most people don't understand is that what happens when we run into somebody for the first time and they've got a small amount of drugs in their possession, or they've made a small sale, you know, for the most part what we do is we give them what's called a 15218, and that's a specific Minnesota statute. It's a discharge and dismissal. So what they get is a stay of adjudication. They haven't been convicted of a crime. They're on probation for some period of time. If they clear that probation, you know, normally it's up to 5 years. If they clear that probation, then they've never been convicted of a felony, and they can go on with their lives without that hanging over their heads for the rest of their lives. And so I think people think we take first-time drug users and we send them to prison and we forget about them. That isn't what happens. And our concern, of course, are the people who are moving lots of stuff and who have lots of things in their possession, and making sure that we're protecting the public from those folks. But the people who have substance abuse issues, those are the ones we want to be putting in drug court. But the people who are making a living off of dealing drugs and aren't just users trying to support their habit, those are the ones that we think need to go to prison. And that's what the County Attorneys Association recommendation does, that I think the Guidelines Commission recommendation doesn't necessarily do.
Ah. Have you ever argued a case before the U.S. Supreme Court?
I have not. I did. I filed a couple of petitions for cases, but they were rejected. You know, the U.S. Supreme Court hears something less than 1% of those cases. I think out of the thousands of petitions they receive every year, I think they hear less than 100. So it's a pretty rare deal for somebody to get one of those cases up to the
You've been before the Minnesota Supreme Court?
I have. I've briefed cases in the Minnesota Supreme Court, but I was what they call amicus curiae, so I didn't get to argue, but I have filed briefs in the Minnesota Supreme Court. We had our office had a Minnesota Supreme Court case earlier this year, but I had my appellate attorney argue it rather than go up there myself and do it.
Is it something that's kind of on your bucket list? I mean, in your profession, I would think it would be something you'd want to be able to do. I don't know.
Well, it would be great, but also terrifying to get to the U.S. Supreme Court. And so I wouldn't want to mess it up. I'd be more concerned about messing it up than I would be about going in there and arguing it myself. I might let somebody who really knows the case well, rather than bump somebody else out of it, which is what I decided to do, is let the lawyer who'd been working on the case in the Court of Appeals and the Supreme Court go argue the case at the Minnesota Supreme Court. You know, it's not about, I try not to make things about my own ego. I try to make them about getting the best result for our office.
Yeah, I'm glad to hear that that's the route you decided to go. The reason I bring this up is there's a case before the U.S. Supreme Court on Minnesota's implied consent law, right?
Right. And that's
just a couple days ago they argued before the U.S. Supreme Court.
Right. State v. Bernard in Minnesota.
Dakota County guy.
Dakota County case. And yeah, that was argued. The Dakota County Attorney's Office argued it on behalf of Minnesota. It was combined with another case from North Dakota, and someone from North Dakota was arguing that part of it. So they had a couple of perspectives and a couple of questions to resolve at the same time there.
But in doing a little research for today's show, I know it's hard to believe, but I do a little research for the program. I've noticed that this is blowing up all over the country. Hawaii's recently had a state Supreme Court ruling there. Kansas and probably other states too are addressing this issue. And this has been around for a while. How come it's taken this long?
Well, every time it's come up before, it's been pretty soundly rejected, this challenge to the idea of an implied consent law, or challenge to the idea of refusing as a crime. And as we've talked about before, and you know that I spent 20 years as a defense attorney, so I've argued the other side of it before. But what happened that has created this space for more argument was a case a couple of years ago called Missouri v. McNeely. And McNeely was a guy who was arrested on suspicion of DWI, and Missouri's law allowed them to do a blood test without a warrant and without his consent. And the U.S. Supreme Court, after hearing the arguments in that case, decided a blood test is a pretty severe thing. You know, sticking a needle in somebody's arm and taking some blood really is constitutionally a search, and you need either consent or a warrant, and without either one, that one was going to be invalid. And so McNeely kind of created this space for argument, because the theory behind all of the implied consent laws and all of the statutes that we've relied on for the last 20 or 30 years was that there's no way to get a hold of a judge in time to get a warrant, because you know the blood alcohol level is likely to change because you're sitting there in the police station. You know, your body is processing the alcohol, it's cleaning out. So if it takes an hour or two for us to get a search warrant and find out what your blood alcohol level is, it may not be what it was at the time you were driving. And so then we're not going to have such good evidence. But the U.S. Supreme Court said, in all the cases that we've had prior to that, relied on that, what they called the evanescent nature of the blood alcohol evidence, that that decline is going to be important. So what they said is that is no longer a basis for an exception to a warrant requirement, and if you're going to have a blood test, at least you had to have a warrant or consent. And so all those cases came back then to what about the blood and the urine cases? Because in Minnesota we give people the opportunity to take a breath test, and does a breath test require a warrant? We have an opportunity for people to take a urine test. Does that require a warrant? And we've had a couple of Minnesota Court of Appeals cases that have talked about a urine test probably requires a warrant too. And so we're asking now in Bernard, the Supreme Court is being asked to resolve the question: does a breath test require a warrant? Does a urine test require a warrant? Or can we rely on what we've relied on for the last 30 years or so, which is you have a driver's license in Minnesota, you're operating your vehicle in Minnesota, and therefore you have implied consent to a search if the officer believes that you have blood, that you have a high enough blood alcohol level that you're a threat to public safety. And so that's the question that the court is going to have to resolve. Does that require a warrant? And what they're bringing it under now is this idea of refusing, because what happened was they would ask people if they want to take a test. People said, no, I don't want to take a test.
And then they're charged with refusing.
the legislature made it a crime to refuse, and this happened while I was practicing, that they said, okay, if people are going to refuse, we'll make it a crime to refuse. In fact, it's a misdemeanor to take the test and fail the first time, and a gross misdemeanor to refuse. So it's a bigger penalty to take the test and fail, or to refuse, than it is to take the test and fail. And that's, I think, where we are seeing these challenges to the refusing statute, because we relied on that for a number of years as, well, okay, you didn't take the test, so now we've charged you with refusing, and that's been a way to resolve these cases without getting a warrant. But I think what the court is really saying is, with modern technology, it's a lot easier for us to find a judge. We don't have to drive to the judge's house and wake him up at 3 o'clock in the morning. We can call him at 3 o'clock in the morning and wake him up, and talk to him over the phone, and have the judge determine whether or not there's probable cause, and issue a warrant on that basis.
Of course, they could have done that before too. I mean, we've had phones for a long time.
Right, and I think that's the real issue, is that we have, the officers have access to cell phones. They can now, if they're taking somebody to the station, I think from what I read about the court's
Sure.
argument, what the justices were really kind of saying is, why can't you just call a judge on the way to the station and make your application for a warrant, and then get the blood test or breath test or urine test on the basis of a warrant? And I think that's kind of where they're going. And it's been an argument the defense attorneys have been making for about 10 to 15 years. But this is the first time it's kind of gone very far.
Well, it does seem like it's a violation of my constitutional rights.
Well, and that's the Fourth Amendment says you have a right to, you can't be subject to a search without a warrant issued based on probable cause by a neutral and detached magistrate. And the Fifth Amendment says you can't be required to provide evidence against yourself. And so defense attorneys have long argued that there was a sort of constitutional exception for DWI. And now they're trying to get rid of that. But I think in the meantime, what's going to happen is that as we just get warrants for all of these cases, and we have blood tests, we're going to have excellent evidence of what the blood alcohol level is obtained by warrant. And so I don't think it's going to hurt law enforcement in that sense. The one thing that is going to happen is that the implied consent revocation, where we take their license right away, is probably going to go away for some time, because at the moment the implied consent law doesn't allow the suspension of the license based on a blood test pursuant to warrant.
And they have to redo all our licenses, because doesn't that say right on your license on the back? I don't have mine with me at the moment, and it's in my coat.
Yeah, I'd have to find my reading glasses to read it, but
oh, that's okay. I think it says on the back, the implied consent. I could be wrong on that.
I'm not sure about that, Gordy. I'd have to look.
That's okay. We won't make you put on your reading glasses, because I only got a few minutes, and I wanted to touch on your relationship with the law enforcement agencies. What brought this up in my mind was the suspicious package that was found earlier this week on the grounds of the Government Services Building, and the sheriff told me that they would do the investigation and they would forward whatever they found to your office for possible charges, which obviously tells me that they do the investigative legwork, they put together whatever they have, it goes to your office, and then whether or not charges are filed is solely based on the county attorney's office.
And that's the process in Minnesota. I know on TV you see, and sometimes on the radio and in movies you hear that the district attorney is starting an investigation. But in Minnesota, the law is that my office doesn't investigate. And what happens is we rely on the reports of law enforcement. If we get reports from law enforcement that we think need more information and more detail, we might send back a request for more investigation, ask them to go out and look at things. We don't have our own investigators. We don't have our own resources for that, and we don't do our own investigations. We simply rely on the reports of law enforcement. As I said, if we think there's more detail, more questions that need to be answered, we can ask them to answer those for us. But we don't do our own thing. But that's our process. We get the reports from law enforcement. They may have a recommendation for what they think needs to be charged or not charged, and we make our own independent evaluation, and that's the process. You and I talked about before why my office is elected, and that's part of it, is to have the independence. The sheriff is an independent elected official. I'm an independent elected official, and we have our own duties and responsibilities, and we obviously work together, but we have our own obligations, and we may not always agree, but we're always, we always have an open dialogue about situations to make sure that we're protecting public safety.
So I'm guessing you on a regular basis, or maybe not, yes, I'm asking, on a regular basis, do you meet with investigators from all the law enforcement agencies in the county and talk about, making sure that the evidence is secure and all that?
Well, I meet with the chiefs, the sheriff and the 5 chiefs every couple of months to talk about things that are going on. But we rely on them to run their departments.
Sure.
and meet the guidelines. But if there's a problem, we certainly let them know where we see a problem. But we have excellent professionally run departments here in Rice County who do just really very good professional work. And so I don't know of any problems that need to be resolved, but if I did, I would let them know right away.
It has to be refreshing to have that. I'm sure not every county has that.
No, not every place has that, and the news bears that out. But I think Rice County is incredibly lucky to have departments that are run very professionally by very smart professional officers, and just excellent departments. And I don't think you'll hear a lot of complaints about Rice County law enforcement doing things poorly or unprofessionally.
Yeah. Well, we've about run out of time. I certainly appreciate you coming in, though. It's nice to get educated on some of these topics. I'll be very curious to see what the Supreme Court rules. I got a hankering that it's going to come down the way you're thinking, too. They're going to have to get a search warrant. No more refusing being a crime.
And I think that's, I guess that's my sense of it based on the argument. And frankly, as I said, I think we can deal with that. And that's the way we're heading at this point anyway, that if people come into contact and we think there's an issue and enough evidence to get a search warrant, we get a search warrant. I'm not sure the district court judges are going to like that, awakened at 3 o'clock in the morning regularly. And they're going to have to find a way, I think, district-wide to deal with that so that we don't have to go out and pester the individual judges all the time.
Yeah. Hey, thanks, John. Appreciate it very much.
Thank you very much.
John Fossum, Rice County Attorney. On Monday, by the way, Dr. Parker's scheduled to be with us, the president of South Central College. Dr. Stromer will be with us Tuesday from the Orthopedic and Fracture Clinic. And we have a DNR conservation officer with us Wednesday. You're in tune to